Any mention?
Yes.
But I like to make a mention of item 4, my lord. I've taken the consent of my senior also.
This no settlement was done till now.
My lord, because my party is not well, so I could not meet him. But my lord, what we have decided is that my lord will approach once more by way of
Try to
representation.
settle. You see, like you do not know what you will get it here.
My lord. So that is exactly why, my lord, I'm praying for some time.
And if it is your business, then we have to.
That
think
is the
also.
point, my lord, because my whole livelihood depends on that.
Yes.
Yes, my lord.
No objection, Your Honor.
When?
I'll pray for 3 weeks, my lord.
The request of the petitioner, not objected to by the learned counsel, appeal for the respondent. This after 3 weeks. See, just something comes out.
My lord.
If you are not sincere, then that's the problem. You
No,
just-
no, no.
You
my
have
lord.
to.
Yes, we are sincere, my lord. Obliged.
Please, Lordship.
Yes.
I'd like to mention item number 10, Lordship, for the private respondent number 2. In 2
Yes,
weeks'
who's
time,
the
we
other
can.
side?
We are going for the state.
2 weeks' time may be given, Lordship.
No objection,
You are appearing with the response number?
2, Lordship, private respondent.
Yes, the request. No problem. No problem. Request may not be with the response number. This is met after 2 weeks. Yes.
Obliged.
Please, Your Lordship, I beg to make a mention part of the hearing list item number 7, Your Lordship.
Yes.
This has been dragging on for quite a long time because if this matter can be fixed after 4 weeks and on that day it can be taken up positively, Your Lordship.
Matter fixed on
After 4 weeks.
after 4 weeks.
Yes,
It's
Your
not
Lordship. And
very
it can be
long.
taken up positively. Both the council can have a vote and it can be taken because the council, in this case, the senior council is coming from Guwahati. So on.
Yes, Mr. Agarwal also appearing.
Yes,
isn't
Your
it?
Lordship. He is appearing. Yes,
That
Your
is
Lordship.
okay, but then Dr. Mojika is here always.
On that, but before whenever this senior council come from Guwahati, Mojika always takes time. So, if
No,
we
but
can,
then you can always have contact. That is the adjustment by the bar members.
Yes, sir.
You should cooperate with each other. We'll have it after 3 weeks, not 4 weeks. 4 weeks
okay,
is
yes,
too long.
Lordship. No,
No problem. Just is for the request may not be of that. You're appearing. Oh, there is only one respondent.
only one respondent, yes, Lordship.
What is the issue involved here?
Actually, the court has passed an order to disclose the one particular document, and against that,
That privilege
yeah,
communication.
privileged communication, yes, Lordship.
Yes. After 3 weeks, the request may not be of such. Yes.
I'll oblige, Your Lordship.
The proceeding is suspended,
Suspended state, yes, Your Lordship.
so you can relax.
We can realize not that.
Yes.
I'll oblige, Your Lordship.
Your Lordship, I beg to mention item number 9, Your Lordship.
Yes.
Let it come after 2 weeks, Your Lordship.
Lordship can have it next week, subject to Your Lordship's convenience.
Why? What is the urgency?
I have been asked to take.
You've been asked.
They have already informed that they
You are
will be
not
seeking-
machine, isn't it?
No,
You
not.
are there in the case.
Yes.
Yes.
2 weeks, Your Lordship.
Only 2 weeks.
The request of the petitioner list after 2 weeks. Yes.
Obliged, Your Lordship.
Yes.
Item number 1.
May I please, Your Lordship?
Yes.
We served the notice for respondent number 5 and 6, Lordship. Some more time to obtain instruction, Lordship.
Have you checked the status of service?
Not yet, Lordship.
The official indicates that it has not been returned. Service report has not been returned. See, have you seen there is the notice issued to respondent 6 has been returned unsolved.
I don't have
You must
instruction.
check office note before you stand up.
Yes. Took steps.
What you will do with regard to 6? Because waiting will not serve any purpose.
Take fresh steps. Take fresh steps.
Yes, Lordship, we will take press steps, Lordship.
But then you have to verify this address.
Okay, Lordship.
And what about response number 5? What you will do?
Some more time to obtain instruction, Lordship, for this.
What instruction?
If it's returned, then I will take fresh step, Lordship.
Notice was issued on 11/4. Quite sometimes now. You verify the status of response number 5
Okay, Lordship.
and take steps accordingly. And so far as 6 is concerned, you have to take fresh steps.
Okay, Lordship.
Yes, just say. Office note dated 30/4/2025 indicates that notice upon the response number 6 has returned unserved. With a note that no such person was found out. Step. The petitioner shall verify the address of the response number 6 and take fresh steps for issue of notice within 3
1
days.
week. 3 days.
Within 1 week. You verify the address
Yes,
within 1
Lordship.
week. Then just say paragraph further office note dated 5/5/2025 indicates that the report of service upon response number 5 is yet to be received. Stop. The petitioner shall verify the status of service upon the response number 5 and take appropriate steps accordingly. List after.
2 weeks, Lordship.
If you take steps within 1 week, then listing after 2 weeks will serve any purpose. List
But
after
2
3
weeks.
weeks. The problem is.
Highly blessed,
Team
Lordship.
leader.
Item number 2.
Yes.
I'm entering appearance, Lordship, for respondent number 1. I've
Then?
just received instruction, Lordship, to appear
We are yet to.
and
Okay.
yet to execute my Vigat amounts.
Yes. Mr. Kharkhan, Learned Counsel has entered appearance on behalf of the. There is only one respondent.
2, Lordship.
Your Lordship.
There are 2 respondents.
Yes, Your Lordship.
No, there are. We will enter appearance on behalf of the respondent number, so both the respondents.
No, Lordship.
There is one pro forma respondent.
I'm only entering appearance for respondent number 1, Lordship.
No step was taken for service of notice upon the pro forma respondent.
The notice is sent, Your Lordship.
Yes,
Will inquire, Your
the
Lordship.
record was number 2 has been received. Okay, 2 has been served,
Yes, Your Lordship.
but then nobody is appearing for 2. This 1 and 2 they are not related.
No, Lordship.
This
They
one number
get
1 and 2
divorced, Your Lordship.
No, we're not
they are not related. Just say office note, the office note dated 1/5/2025 indicates that the notice upon the response number 2 has been effected.
Your Lordship, in the meantime, the interim prayer for this case will continue.
There is no interim order passed earlier. There is no interim order here. Just a minute. Just a minute. The court has. What is it? As I was saying. However, none appeared for the said respondent. When the matter is called out, stop. Then we give a paragraph. Mr. Kharkang, learned counsel, has entered appearance on behalf of the respondent number 1 and sought for grant of some time to obtain necessary instruction. Prayer allowed. List after?
2 weeks. Okay.
After 2 weeks.
Legit.
Yes.
Item number 3.
My lords, I beg to appear online on behalf of the petitioner in this matter. This is a quashing petition, my lords.
Yes.
My lords, I am seeking some time in this matter. Actually, I'm being led by a senior advocate here from Delhi, and due to some personal difficulty, he couldn't travel. So, if I can give it a say. And my lords, I believe the respondent also, we have not received any reply from them.
Receiving reply means you mean to say written reply or response to your petition?
Yes.
Is it necessary?
Indeed.
What about respondent number 4? No step has been taken. Yes, you have not taken steps for service of notice upon the respondent number 4.
My lords, I'll just confirm that we will take it in the meantime before the next meeting.
No, for taking steps. Court had given you 2 days time. You have to take steps.
My lord, we'll ensure notice within a week, my lords.
I think this is not under state, isn't it? 4 is, I think, center. This.
No, my lords, it is also
That is
part of
precisely the Advocate General did not appear for the last occasion.
Yes, my lords. It is part of the state, my lord. It is part of the state.
This is part of the state.
So we can represent, my lords.
Why there was an order to take steps to... Okay. No, you entered for respondent number 3.
1, 2, 3, my lords. It can be, my lords. The statement can be recorded. We are representing 1, 2, 4.
Are you sure that this is part of the state?
Yes, my lords.
National Highway Division may not be...
It is National Highway Division, PWD, Shillong, Meghalaya. So it is...
Shillong, Meghalaya doesn't mean that government of Meghalaya.
Yes,
it is
my lord.
located in Shillong, Meghalaya.
I'll take instructions, my lord. And that, but as per my understanding, it is...
So far as the order is concerned, they are bound to take steps.
Yes. Yes, my lord. They are bound to take steps.
But then, no, there is nothing.
But it says issue notice, Mr.
Yes, that is
necessary.
That should have been.
It can be, my lords, because I have some background knowledge of this matter, my lords.
Okay, so
yes, my lords, it is.
So you can say they will represent respondent.
1, 2, 4, my lords. There may not be any requirement.
Okay. Yes, Mr. Raghuvanshi. Yes, how much time you want?
My lords. My lords, I may be kept in last week of June, my lords, if it is possible.
Last week of June. That is too
my lords,
long. Things doesn't go that way here.
My lords, the only difficulty is, if I may put it up close. My lords, June is actually summer vacations in Delhi. That is the reason the
that may be your thing.
May not be available.
Will not go that way. We'll have it after 3 weeks. We'll adjourn it for 3 weeks. If you need some more time, you ask after expiry of 3 weeks. We'll see.
We will appear after 3 weeks.
So, just see at the request made on behalf of the led by Mr. Raghuvanshi, Mr. A. Raghuvanshi, learned counsel appearing for the petitioners. You just say not objected to by Mr. Pandey, learned counsel appearing for respondent number 1, 2, 4. Do not make it 3. So that there remains nothing. Okay, list is met after 3 weeks. Yes.
Obliged.
Hearing item number 5.
Any interim here? No.
No. Interim.
Yes.
Obliged.
After 3 weeks.
Please, my lords.
Yes.
Lords, this is a challenge to the publication dated 19/6/2019, my lords, whereby the name and photograph of the petitioner was published, my lords, as a willful defaulter. This is that matter, my lords, where my lords had directed the bank to produce the records. The bank, my lords, has come back and said that they don't have the records, and as such, they're not in a position to produce the records before your lordships.
What kind of relief can be granted to you at this stage?
My lords, that notification, whatever was published, my lord, it has to go. But then I would have remedy under law, my lords.
There is a remedy.
My lords, because it would be defamatory to me, my lords, insofar as I am concerned. Because there is a procedure, my lords, under which this entire process is to be done. It's not, my lords,
That is all right. That is all right. So, supposing if you come to finding that that entire process was wrong,
not done, my
and
lords.
the publication was not as per law,
My lords.
then what kind of relief can be granted to you at this stage?
My lords, that notification has to go up, whatever that, because there is a list that is published of willful defaulters, my lords. My name continues to be in that list, even today.
Okay. So that is in respect of some loan,
Lordships.
and that is not yet clear till date. Yes.
That is a loan, my lords, if I'm not mistaken, that was taken sometime in the late 80s.
And that has not been cleared yet.
That, my lords, in respect of that, the proceedings are pending before the DRT now.
All right. So far as the recovery is concerned.
Lordships.
Yes.
My lords, I will take your lordships first to, my lords, Annexure 2, page 13. Annexure 1, my lords, first. If your lordships kindly have a look, my lords.
Yes.
My lords, this is a publication on the Shillong Times on the, my lords, Friday, the June the 21st, 2019. Whereby, my lords, this was published.
Yes.
Publication of photograph of willful defaulter. Notice is hereby given to the public at large that the Indian Overseas Bank has declared the following persons as willful defaulters in terms of the bank's RBI's extant rules and regulations complying with the due process prescribed therein. This is a, my lord, nationalized bank which is publishing that we have followed the procedure in declaring this person as a willful defaulter. My lords, they give my name. Bank has sent suitable communication to the borrower informing of the decision of the bank to determine him as a willful defaulter. As permitted by the Reserve Bank of India, bank publishes the photographs of willful defaulter for the information of the public at large. So it is almost, my lords, defaming a person, saying that this person is a willful defaulter. Process has been followed. We are publishing it for general public information. That is after, my lords, there is a list of willful defaulters throughout the country. After the name, my lords, appears in that list.
There is a rule which says, of the Reserve Bank, which says that you publish this thing.
Lordship.
There is.
It is there.
Anything about 25 lakhs, any outstanding loan above 25 lakhs.
Not
The policy is to defame the public, defame the
No,
person
so
in front
not
of public.
defaming him, not with the intention of defaming, but with the intention that the other banks know that he is a defaulter and that he will not be easily accessible
Was
to.
there a requirement of making a publication like this for this thing? Of course, we cannot challenge.
That
policy.
is the-
It could have been done by internal communication.
That has been done many
Well, it's
times.
mal-
Now the publication is required so that the banks and everybody knows that he is a defaulter,
Anyway.
and nobody else will give him a loan.
Okay, it's all right.
That is the
Lords, these
Reserve
days-
Bank
Lords,
guideline, Your Lordship.
That can be done. Yes.
Well, I would strongly dispute what my learned senior is saying, because these days when you go to a bank for a loan, my lords, even a smallest of loans, there's something called a civil score. If I am a defaulter, my lords, as against a willful defaulter, if any person has defaulted in payment of even a single installment of a loan, it affects your civil score. CIBIL score, they call it. CIBIL score. So there is no question of informing other banks through newspapers. Be that as it may, my lords, I'll take your lordships to the procedure that is at Annexure 2, page 13.
Yes.
Now, this is the master circular, my lords, issued by the Reserve Bank of India. This is dated, my lords. May I just read Annexure 2?
Please.
Please refer to the master circular number so-and-so dated July 1st, 2014, consolidating instructions, guidelines issued to banks, FIs till June 30th, 2014 and updated as on 7 January 2015 on matters related to willful defaulters. This master circular consolidates instructions on the matters up to June 30th, 2015. Now, thereafter, my lords, I'll jump, my lords, if your lordships kindly come to page 15, 2.1.3, my lords. What is a willful default? There's a stark contrast against default, my lords. A willful default would be deemed to have occurred if any of the following events is noted. The unit has defaulted in meeting its repayment obligations to the lender, even when it has the capacity to honor the said obligations. The unit has defaulted in meeting its repayment obligations to the lender and has not utilized the finance from the lender for the specific purpose for which finance was availed, but has diverted the funds for other purposes. C. The unit has defaulted in meeting its repayment obligations to the lender and has siphoned off the funds so that the funds have not been utilized for the specific purpose for which finance was availed of, nor are the funds available with the unit in the form of other assets. The unit has defaulted in meeting its repayment obligations to the lender and has also disposed of or removed the movable fixed assets or immovable property given for the purposes of securing a term loan without the knowledge of the bank. The identification of willful default should be made keeping in view the track record of borrowers and should not be decided on the basis of isolated transactions incidents. The default to be categorized as willful must be intentional, deliberate, and calculated. Only in these circumstances, my lords, a default can be termed as a willful default. I have the capacity to pay, but I choose not to pay. I take a loan for purpose X, my lords, I use it otherwise. Or I take a loan, my lords, and I siphon off that fund. These are the grounds on which, my lords, and of course D, my lords, that if the assets standing on the property are disposed of by me without the knowledge of the bank. So only under these circumstances I can be identified as a willful defaulter. Now, my lords, for the purposes of, my lords, identification, there's a procedure laid down. If my lords kindly come to page 21.
Yes.
My lords, my lords may kindly come to 3, my lords. Mechanism for identification of willful defaulters. The mechanism referred to in paragraph 2.5 above should generally include the following. The evidence of willful default on the part of the borrowing company and its promoter, whole-time director at the relevant time should be examined by a committee headed by the executive director or equivalent and consisting of 2 other senior officers of the rank of GM and DGM. If the committee concludes that an event of willful default has occurred, it shall issue a show cause notice to the concerned borrower and the promoter, whole-time director, and call for their submissions, and after considering the submissions, issue an order recording the fact of willful default and the reasons for the same. An opportunity should be given to the borrower and the promoter, whole-time director, for a personal hearing if the committee feels such an opportunity is necessary.
Just a minute, Mr.
Malak.
Paul, just before you proceed. Now, the word used in that 2.1.3,
Malak.
you said that unit.
Unit
Yes.
includes individual, my lords. Unit includes individual.
The provision which you are reading right now,
My lords.
that basically concerns the borrowing company and.
My lords, these expressions are used interchangeably. Unit, borrower, and company, my lords. I can just show that, my lords.
It's there. It's 2.1.
2.1.2.
Yes.
The term unit includes individuals, juristic persons, and all other forms of business enterprises, whether incorporated or not.
Yes.
So that would be company would be included.
Yes.
Well, it's then the order of the committee should be reviewed by another committee headed by the chairman and managing director, or the managing director, chief executive officer, CEO, and consisting in addition to 2 independent directors, non-executive directors of the bank, and the order shall become final only after it is confirmed by the review committee. However, if the identification committee does not pass an order declaring the borrower as a willful defaulter, then the review committee need not be set up to review such decisions. As regards non-promoter, my lords, this may not be relevant for our purposes. If I may just go down below, my lords, there is therefore, if my lords kindly see. After D, therefore, except in very rare cases, non-time, my lords, again, not relevant. This is with regard to non-promoter, non-whole-time director in respect of companies. So that would not be relevant. What it basically says is, my lords, if I can just put it in short, is that, my lords, first there is an identification committee. The quorum of the identification committee is mentioned, my lords. They would first identify that yes, this loan falls in that category of 2.1.3, and, my lords, there's an initial identification. After that, my lords, 3B mandates that a show cause notice has to be issued to the concerned borrower why he should not be declared a willful defaulter. Then, my lords, he files his reply, which is considered by the committee, and, my lords, an opportunity of hearing is to be given to that person. That is now the law which has been settled by the Honorable Supreme Court. After that, my lords, it goes before a review committee. And, my lords, what is very important is, your lordships will kindly see what is the quorum of the review committee. It goes right up till the chairman. It is the chairman, managing director or managing director, chief executive officer, CEOs, consisting in addition to 2 independent directors, non-executive directors of the bank, and the order shall become final only after it is confirmed by the review committee. It is only after following this procedure, my lords, that any person can be called a willful defaulter. And thereafter, my lords, one of the thing is that then there is a publication. Of course, it is never with a photograph. For the first time, my lords, there is some photograph which has been published. It is usually by the name of the institution.
Where do you get that part of the provision which deals with publication?
My lords, I will just take your lordships. Just show me that relevant portion. No, there is publication is there. Just go back to that. The Gujarat judgment, it's there in the Gujarat judgment. Well, it's, this is, my lords, 4. It deals with criminal action against defaulters. My lords, CIBIL, what I was talking about is at 5. This is the credit information companies, my lords. We'll see.
Where is that page?
Page 24, my lords. My lords have, my lords. Credit information companies disseminate information on non-suit filed and suit filed accounts respectively of willful defaulters as reported to them by the banks. FIs are by banks, FIs, and therefore the responsibility of reporting correct information.
Reading which part?
Well, it's 5.1, my lords.
Yes.
Reporting.
Which is need for ensuring accuracy.
Accuracy. Credit information companies. This is CIBIL, my lords, what I was talking about. Disseminate information on non-suit filed and suit filed accounts respectively of willful defaulters as reported by them to by banks, FIs, and therefore the responsibility of reporting correct information and also accuracy of facts and figures rests with the concerned banks and financial institutions. Banks, FIs may also ensure the facts about directors wherever possible by cross-checking with the registrar of companies. My lords, this is with regard to CIBIL. Insofar as publication is concerned, my lords, I'll just point it out. It is there, my lords. It is never usually, it is not with a photograph.
Fact remains that according to them, you were willful defaulter.
My lords.
Now you are challenging that part.
My lords.
Now, what part of the guidelines or the norms was not followed?
My lords, nothing has been done. Which is why I say, my lords, there has to be an identification. After identification, my lords, a show cause has to be given to me. I file my reply. Whether I choose to file, I don't file, my lords. I have to be given an opportunity of being heard. Then the matter goes before the review committee. Review committee then comes with a finding, my lords, that this person is actually a defaulter, willful defaulter. And my name gets published in the list of willful defaulters.
Now, whether adherence to those instructions is mandatory.
My lords, that's what the Honorable Supreme Court says, that even though these are guidelines, my lords, that there has to be adherence to these rules of the Reserve Bank of India. Show me those judgments.
What grounds you have taken in your writ petition?
My lords, I have taken very specific grounds, my lords, saying that it has not been done.
Okay. None of the procedure prescribed
My lords.
was followed.
My lords.
And what is the affidavit? What is the affidavit filed by the
My lords,
respondents?
I'll take your lordships to the affidavit. Sorry. If I may take your lordships to page 5, paragraph 12.
Of their affidavit.
Of their affidavit. my lords. Well, first I'll take your lordships to paragraph 7 of my writ petition because it is in response to paragraph 7.
One.
Take out the law. In the list of books. What is that? The publication. My lords, may kindly have a look at page 6 of my writ petition, my lords,
Yes,
paragraph 7.
Yes, please go ahead.
Well, may I read, my lords?
Yes.
That the petitioner states that meanwhile, to the utter shock and surprise of the petitioner, the respondent bank all of a sudden, via the impugned publication dated 19/6/2019, published in the local dailies on 21/6/2019, had published the name and photograph of the petitioner and further declared the petitioner as a willful defaulter in absolute abuse of the powers and non-compliance of the mandatory guidelines as contained in the RBI Master Circular dated 1/7/2015, which is what we were running through, my lords. It is pertinent to mention herein that no communication or show cause notice as mandated under law was served upon the petitioner, and without affording any opportunity of hearing, the petitioner was also declared as willful defaulter by the respondent bank. Besides, no order passed by the respondent bank declaring the petitioner as willful defaulter is found mentioned in the impugned publication dated 19/6/2019, which itself establishes the fact that the entire exercise undertaken by the respondent bank in publishing the name and photograph of the petitioner was done in absolute abuse and non-compliance of the mandatory guidelines as contained in the RBI Master Circular. Now, to that, my lords, they say in paragraph 12 at page 5 of their counter affidavit,
Yes.
May I just read paragraph 12? Madam? That the statements made in paragraph 7 of the petition, it is humbly and respectfully stated there is no reason whatsoever for the petitioner to be shocked or surprised in seeing the photograph in the daily local dated 19/6/2019 as a willful defaulter, because the petitioner is a willful defaulter who has not paid the dues of the respondent bank and continues to drag the respondent bank into one litigation after another. It is denied that the respondent bank has not complied with the mandatory RBI guidelines as alleged. In fact, the respondent bank, through its head office in Chennai, has issued notice to the petitioner in this regard sometime back, as per the RBI guidelines, but unfortunately, the same could not be retrieved or recovered. However, that does not change the fact that the petitioner is not a habitual defaulter, in as much as the conduct of the petitioner all along will go on to show that he has been and is a habitual willful defaulter. It may please be noted that there is a clear case of the pot calling the kettle black. The petitioner is a habitual willful defaulter who has not paid a huge amount of the respondent bank's outstanding dues in spite of repeated demands, and when the respondent bank is bona fide and generally trying ways and means to recover the public money from
Those part we are not concerned with.
My
This. We will not go and determine the thing whether
My lords. Now,
just
what I'm
whether procedure has been followed or not.
now what I'm submitting is, my lords, I'll take to the orders passed by this honorable court, my lords. I will first draw your lordship's attention, my lords.
There is no rejoinder filed by you, isn't it?
No, my lords, I have not. Order of production of records. My lords, may I draw your lordship's kind attention to the order dated 19/8/2024.
Yes, 19/8/2024. So what
My
is-
lords.
Yes.
My lords, may I just read it?
Yes.
Heard learned counsel for the parties, considering the nature of the controversy involved in this matter, it is deemed appropriate to call for the records of the proceeding by which the petitioner was declared a willful defaulter, and a publication to that effect was made on 19/6/2019. The respondent bank shall produce the records on the next date of hearing. From then, my lords, time was taken repeatedly.
That affidavit says the notice could not be traced. They did not say the entire file went.
File is missing. The nationalized bank issues a notice, my lords, not
And there
received.
is no question. They have to show us something. Anyway, and then
My lords, then the next relevant order would be, my lords, the order dated 8/4/2025.
Yes.
Learned senior counsel appearing for the respondent number 1 and 2 submit that the record which was required to be produced before this court could not be located, and hence the matter may proceed without production of the same.
You have read out the order dated.
My lords, this is 8/4/2025.
8/4. Okay.
So the my lords, they finally come before this honorable court and say the records could not be located and the matter may proceed.
So almost after 8 months.
8
come
months,
and
ma'am.
say that,
That
it
the
is-
records could not be found. My lords. The entire records have disappeared.
Yes.
Well, it's two aspects, if I may humbly submit here. Paragraph 12, my lords, of the counter affidavit is a deliberate attempt on the part of the bank to mislead this honorable court. And that's filed on oath. Because the verification of paragraph 12, if my lords kindly have a look at paragraph 18,
Paragraph 18 of.
my lords, the verification of the affidavit, my lords, at paragraph 18, my lords may kindly have a look. Because in my humble submission, my lords, it's a very serious matter to swear an affidavit before this honorable court and with a deliberate attempt to mislead this honorable court.
It is to the.
Deponent.
It is.
Deponent is.
True to the best of the knowledge derived from the records.
It is from official records.
It has to be.
But,
You see,
my lords, now the
thing is
records
that-
have disappeared.
Now, the thing is that the very fact the officer who signed it, whether he was
Privy to the records at that point of time.
okay, where is that? Para 18.
Para 18, my lords, they say that the statements made in paragraphs so and so are true to my personal knowledge, and those made in paragraphs 10, 11, 12, my lords, 12 is relevant.
So if something went missing, how, on what basis?
So it must have either disappeared from his custody.
Who is the officer who signed it?
My lords, he was one Mr. Shah, my lords, Debraj Shah. So either, my lords, there's a case of misleading this honorable court, or the records have disappeared from his custody. He is a senior official of the bank. And interestingly, my lords, he says that even though he says that from official records he sees that a letter has been issued from Chennai, but that letter could not be traced.
No, if a letter could not be traced, then what basis he made the file?
Well, my lords, which is what? It is blowing hot and cold at the same time. He says, my lords, it is derived from official records.
Yes.
At the same time, that record itself is missing. Even not now, my lords, not in 2025. I'm saying when this affidavit is filed in 2019, he says that that letter could not be retrieved, or the two expressions that have been used, my lords. He says
The same officer is
retrieved or recovered.
Same officer is still there in the same position.
Unless Mike, Leonard Senior would be in a better position to apprise
Your
this.
Lordship.
He's the chief manager.
He was the chief manager at the relevant time.
Yes.
Very reckless kind of a statement which is made in the paragraph 12.
Yes, what you will say? Yeah.
May it please your Lordship.
The
Your Lordship, I don't have much to say in view of the fact that we could not recover the records as directed by your Lordship and couldn't produce it. But the fact remains, your Lordship, that in 2019, when the publication was made,
Yes.
when the publication was made, your Lordship will see for yourself in the notice, the published notice, your Lordship, the bank has stated very clearly that notice is hereby given at page 12, your Lordship, an extra one of their petition.
Where is that published?
Notice is hereby given to the public at large that Indian Overseas Bank has declared the following persons as willful defaulter in terms of bank's RBI extant rules and regulations complying
That
with
is
the
the
due
contents of
process.
things. Where
No,
does it-
that means here also, your Lordship, they have said that we have complied with the due process prescribed therein in that bank's extant rules. But
Since it is said here, that is why you have called for the records to verify it.
yes, your Lordship. Now,
So
your
if the
Lordship,
record is
even
not there, then we can
at
say
that
this
point of
publication
time, your
also is
Lordship,
wrong.
your
Totally
Lordship, sorry, your Lordship.
That even now we can say that this publication also is made wrongly.
And to mislead
That is what-
means the
No,
public
why
has been
should we
misled.
mislead? Your Lordship, let me take your Lordship to the background of this case, your Lordship. My friend has said that we are trying to mislead the Honourable Court by declaring him to be a defaulter, willful defaulter, and by swearing an oath that this paragraph. But in this paragraph, your Lordship, which I have, paragraph 12, your Lordship, which was said to be a misleading paragraph, your Lordship may kindly see that we are saying that seeing is putting to the petition, because the petitioner is a willful defaulter. Your Lordship, what has happened in this case, your Lordship, may I give you a brief background, your Lordship? This petitioner, your Lordship, had taken a loan in the year 2002, amounting to more than 1.52 crores, your Lordship, for the purpose of his business. Your Lordship, and for that loan, your Lordship, he had given a security, a property in Silchar, Karimganj, your Lordship, and a flat here in Yakitori building in Keating Road, your Lordship. So those were the two securities which the bank. Now, because he was not paying the loan, your Lordship, this loan became a bad loan, as it is called by the bank. And in 2004, your Lordship, it became a non-performing asset. So when there is a non-performing asset, the bank is at liberty to approach the DRT, Debt Recovery Tribunal, under the SARFAESI Act, your Lordship, for recovery of the amount, because this is all public money, your
And
Lordship.
we have done, which you have done.
We have done, your Lordship. That was, and your Lordship, even in the Debt Recovery Tribunal, your Lordship, one could see the conduct. He is sometimes appearing, not appearing, and then the matter was decided by the Debt Recovery Tribunal, and the bank was given a certificate by which they could go and recover the money which was outstanding against the petitioner, your Lordship. Now, your Lordship, so while trying to recover the money, your Lordship, we had to attach both the properties because those were the securities that were given to us. Now, the Silchar property could be sold only for a sum of rupees 13 lakhs, whereas the amount outstanding had now run into crores, your Lordship. And then the property here in Yakitori building, your Lordship, which is a flat, this gentleman, the petitioner, did not register it. And they claim that it could not be registered.
All were for you to look into before you accepted all those as
No,
collateral.
no, that is okay, your Lordship. But then he had submitted his documents by which
See, normally what this court understands that when certain property is offered as security, then the bank official
will have to
visits it,
check.
they
We'll check
it,
to have the title
and then
is
they have
theirs.
all the formalities of obtaining that title deeds or other
Exactly,
things
your
even from
Lordship.
lawyers.
Exactly.
They are lawyers, and thereafter it is
Yes.
done. So subsequently, if
It was done, everything was okay, Your Lordship, but he had promised to register the property. And because he was a regular customer.
that is
No,
what-
Your Lordship, he was a regular customer,
then
so
what
he
do
was
you have to
giving
do
that.
with all those things?
No, sorry, Your Lordship.
What do we have to do with all those facts? Here?
No, Your Lordship will have to see the conduct. Because the conduct of the man is he is the one
We'll
who's
not go into these things. You see, madam, we are sitting in a jurisdiction. Unlike an appellate court, we will not go into the facts and all.
Okay,
until
Lordship.
unless there is a perversity. Only thing is that we will just see whether the procedure prescribed.
The procedure prescribed,
and
Your
the law has
Lordship.
been followed.
We are saying
And
that.
if you have not followed, then definitely.
No, we are saying that we have
And we'll
followed the
examine
law.
that part also. And
No,
if
we
prepared, we will have to impose some cost on you for misleading the court.
How can we, Your Lordship, how have we misled the court, Your Lordship?
What about the paragraph 12?
Paragraph 12, Your Lordship, we are saying that we have taken the process, the due process of law.
See, there are two
we have
things.
followed.
There are two
but
things.
unfortunately, we are not able to
please,
produce
please,
that.
See, have the patience. There are two things. There are situations which appear against you, as has been pointed out by the learned senior counsel here. By order dated 1908, the record was called for.
Yes, Your Lordship.
Thereafter, 8
took
months
time.
lapsed for you to inform this court that record is missing.
No, we had been trying, Your Lordship.
We
had been trying because the record is not here, Your Lordship.
Wait. See, take the circumstances. Your affidavit says some notice was issued by the head office.
As per the RBI
But then
guidelines.
that notice also is not traceable.
Not traceable,
So,
Your Lordship.
what
So we have
what
honestly,
do you want to say?
we
How
have
many
honestly
things-
said that it is not.
Wait, please wait. How many things you want this court to overlook? Is it not the person who signs the affidavit is a responsible officer?
He is a responsible
Is he
officer.
playing with the court?
He has got instructions from the head office saying that
That's
the
okay.
RBI guidelines were
See,
followed.
on what basis he has filed, we do not know. But then, while testing the veracity of the statement, we will take into consideration the materials which are available.
Your Lordship may take the fact that we have not been able to produce the records, but from the 2019 we are saying that we could not retrieve the documents because the whole documents are not in the custody of this branch, Your Lordship. It is in the custody of the head office.
We take
So many
entire
people
bank
have
as
been
one.
transferred.
We will not make any distinction, you see.
No, Your
What
Lordship
problem
had
you
said that
have
we
in
had taken 8
communication, what
months. Your
problem-
Lordship had said that we had taken 8 months to come back to this court and say that we could not get the
Yes,
records.
yes.
But even at the time, in 2019, Your Lordship, we had already stated that we could not retrieve and recover the documents, Your Lordship. But when Your Lordship had said that you try and produce the documents, we made an effort. We made an effort to try and produce the documents. But in spite of all efforts,
The
Your
time
Lordship,
when this court passed an order for production of record, you did not say that record is not traceable.
the
That
affidavit
was not the
there.
indication.
The affidavit.
Had it been there, court would have recorded it.
No, yes, it was, I think I overlooked that part, but the affidavit, Your Lordship, which was filed in
There is no
2019.
question for you to overlooking. You see, you will act on the basis of
Instructions.
So,
No, that affidavit was already there on record.
unless you have any such instruction, why should you say?
No, the
Now,
affidavit.
once court passes an order, you communicate it to your client.
Yes.
And it is for them to inform you accordingly. So that is where it took 8 months. That is where it took 8 months, isn't
No,
it? This
we
is a
have
court
been
order.
constantly-
It's a court order, and to just verify 8 months, what happened? You employed some lever to find out this where the record is. Can it be something like that?
No, we had this matter was the records were in the head office. Your Lordship,
Anyway,
not
whatever
in
the
this.
thing, you see, we have
But
taken
whatever
note
it
of
is,
the
Your
thing.
Lordship has come to the conclusion that we have not been able to produce the records. So an
Once you have
adverse
not been,
inference.
so we'll say
yes,
that-
I am not saying, Your Lordship. I humbly acknowledge that it is. Unfortunately, we could not produce the records which were. But the fact remains, Your Lordship, the bank is also dealing with public money. It has run into crores, Your Lordship. We are not being able to attach the security, Your Lordship, in spite of the fact that we have got a
understand, but then
certificate.
Can a
You-
court, can a
that
court
may
go
be.
by all those
That judicial
considerations?
notice can be taken, Your Lordship. Your Lordship can
We
be
cannot-
taken
cannot- we
notice,
cannot go by all
and Your
these
Lordship can take a lenient view. Not that we have tried to mislead the court, Your Lordship. There was no intention on the part of the bank to mislead the court because we do not get how do we benefit, Your Lordship.
So the only
How do we
argument,
benefit, Your Lordship, by misleading the court, Your Lordship?
it's
Our
okay,
only concern is to recover the public money.
it is for the court will determine.
Yes, Your Lordship.
Just
will
leave it up to the
determine.
court. We have
Yes.
taken
But our
consideration
only
of-
concern was to recover
So
the money. Your Lordship.
only submission coming from you is that page 12 of the writ petition, whereby you say that the publication itself says that bank has declared him
yes.
as willful defaulter.
But we could not recover the records.
Since it is projected there, So there is an assumption that all the procedure is followed. Is it your submission?
Yes, because that is the instruction, Your Lordship.
You see, you will definitely make submission on the basis of an instruction.
Instructions, Your Lordship.
Yes, definitely. That is what. So that is the only argument.
Yes, Your Lordship.
Okay. What else you want to say? Anything else?
This is the letter which I got from the bank when Your Lordship had directed me to produce the records this time, Your Lordship. That is in...
This is okay. Anything with
that
regard
they
to
have
this
said the same thing, that we couldn't because most of the officers have been transferred.
Anyway, that is your
Those
communication.
officers who dealt with that have retired, the officers have been transferred, so they are not in a position to retrieve the records, Your Lordship. So which is why, Your Lordship, we are handicapped as far as that part is concerned.
Who are the respondents in this case?
Well, it's the
Just
bank is a
Your
respondent.
Lordship. The chief manager and the bank.
The bank itself is a respondent, Pillits.
But Your Lordship, I just want to humbly state, Your Lordship, that there was no intention on the part of the bank to mislead this Honourable Court, Your Lordship, on any account.
Maybe.
The bank is only trying to recover the public money, Your Lordship.
There is a term called responsibility. See, these are high officials. You are expected to move responsibly. We may say that, okay, there may not be any malafide intention.
There is no malafide. It's
then-
only
but then these are-
their
these
only
are-
intention is to recover the money, which we still haven't been able to recover.
Court matters should be given, like a very, it should be given due importance.
Well, it's just two quick replies, if Your Lordship's permit me.
Some more fuel to the fire.
But
Yes.
just two things, Millets. It's this, Millets, that these proceedings, Millets, of willful default, contrary to what my learned senior was submitting on instructions from the bank, are not a piece of paper that can be lost. There is a procedure, Millets, under an act. These rules, Millets, what I wanted to point out are, these rules are, Millets, actually promulgated under, Millets, Section 35A of the Banking Regulation Act of 1949.
So these are not mere executive instructions.
No. And the Honorable Supreme Court, Millets, in the catena of judgments, I'll place it. They say that they have statutory force.
Just a minute.
Normally, the guidelines do not have a statutory force, Your
These
Lordship, but
do.
in this case they have. Your
These
Lordship.
do, because they are-
that is why I'm not taking that plea, Your Lordship.
So, Millets,
You have
proceedings.
You have stood up to say that you are not taking the plea.
No, that is why we've not taken the plea that they have no
Why
statutory
you are getting
force.
agitated? We are in the midst of hearings.
No, I am not getting agitated, Your Lordship.
Millets,
I'm just trying to drive home a point that your court, this honourable court, should not think that we are misleading this honourable court.
no, it's not. I must clarify, Millets. I'm not saying that my
Yeah,
learned
but-
senior is misleading. It's the bank, Millets. The bank is, and I still maintain the position that the bank has been deliberately misleading not only the court, Millets, also the general public in publishing that notice saying that the procedure has been followed. Section 35A, Millets, if my lords kindly have a look.
Capital A.
Capital A, Millets.
Yes. So these rules will have statutory force.
They have statutory force, my lords. And therefore, my lords, the Honorable Supreme Court says that they are to be, these guidelines are to be read as part of the Act itself.
Power of the Reserve Bank.
Power of the Reserve Bank to give directions. Where the Reserve Bank is satisfied that in the public interest or in the interest of the banking policy or to prevent the affairs of a banking company being conducted in a manner detrimental to the interest of the depositors or in any manner prejudicial to the interest of the banking company, or to secure the proper management of any banking company generally, it is necessary to issue directions to banking companies generally or to any banking company in particular. It may from time to time issue such directions as it deems fit, and the banking companies or the banking company, as the case may be, shall be bound to comply with such directions. The Reserve Bank may, on representation made to it on its own motion, modify, cancel directions, but that's the power to modify the thing. So these directions, my lords, are issued by the Reserve Bank of India from time to time, so that a certain procedure is followed, my lords, by banks insofar as willful defaulters are concerned. Because willful default, my lords, has a larger consequence than just a normal defaulter. Anybody can be a normal defaulter, my lords, but a willful defaulter is, as your lordships have seen, a 3.1 point.
They are bound by the guidelines. That is what it says.
My lords. And, my lords, two judgments I'll just very quickly place, my lords. The first is My lords, this is 2020 10 SCC, page 274. This is the case of Internet and Mobile Association of India versus Reserve Bank of India. It's by a 3-judge bench, my lords. And the operative portion of the judgment, my lords, which I'm referring to, is your lordships would find it at page 363, paragraph 150.
It's a long judgment.
Very long judgment, my lords, deals with too many issues.
Paragraph?
1501.
It's 150. Yes.
Law is well settled that when RBI exercises the powers conferred upon it, both to frame a policy and to issue directions for its enforcement, such directions become supplemental to the act itself. In PLS so-and-so versus so-and-so, to hold that rules made under a statute must be treated as if they were contained in the act, and therefore they must be governed by the same principles as the statute itself. In other words, my lords, these rules would have statutory force. Same principle has again been reiterated, my lords, what was already there in PLS. I need not take your lordship to PLS. PLS is...
So if it is on the same position, then it's not needed.
My lords. This is by a smaller bench, my lords. That's a 3-judge bench on a more recent decision, so I'll not trouble your lordships with PLS.
Yes.
Other than that, my lords, with the opportunity of hearing and all that, my lords, a lot of water has flowed, but I need not even go there, my lords, because admittedly nothing has been done.
What is your prayer in the petition?
Well, it's to set aside that. Mandamus against the publication, my lords, dated 19/6/2019. Published in the local newspaper on 21/6/2019. In certiorari, my lords, to set that aside.
There is no other consequential relief.
That, my lords, would mold the relief, my lords. Because when we filed this, my lords, I did not anticipate that this would be in these kind of circumstances. It is expected of a public sector unit, my lords, it's a bank, a nationalized bank at that. And, my lords, then you come up with a publication saying that we've done it as per the master circular of the RBI. And, my lords, most unfortunately, if I may humbly submit before this honorable court, for the bank to now come, my lords, it's not an officer concerned. It is a bank, my lords, a nationalized bank at that, to come and say that records are missing is something that is very dangerous. And there seems to be
better sense should have prevailed. You should have withdrawn. The time when you found that, you should have withdrawn this notification. Even at the time when you found that record is not traceable. At least, especially, you know what happens in the courtroom. You cannot go by assumption. In your personal level, you may know many things.
Once it is published.
This court may also presume many situations when it comes to personal things. But in the court procedures, we are bound by law. All of us, we are bound by law. That is what.
Court can take a lenient view in view of the fact that the money is still outstanding into crores, and this is public money, your lordship. He's not paying it all.
Maybe, my lords, Kasab also has to be given a trial.
Here it's
Kasab has to be given a trial in this country.
See, here it's a question.
This is, of course, this is not a case for recovery of the money, but then the background has also to be
declaration of willful defaulter. Now, that is what the question is.
That is.
Otherwise, so far as the proceeding initiated by you for recovery, it doesn't get affected by that. Because
it's a separate matter altogether, your lordship.
Willful defaulter, or is it defaulter?
It is only unfortunate that in spite of so much time given, they could not produce the record. I am also quite helpless in that regard, your lordship.
We can understand your...
But you see, by only prayers that a lenient view may be taken on the bank. They should not... That is all. Because their only intent... There is no mala fide in that, your lordship. The only intention is to recover the money that is running into crores, your lordship, and nothing else.
No, recovering the money, the publication doesn't help bank to recover money. Publication may make other banks
and also
cautious.
to warn the other financial institutions
that is okay.
That this man is this type of...
See, the activity of a bank should be confined to the interest of the bank, isn't it? So you cannot say, at least you cannot raise this argument that this publication was made just to, you see, like get the money recovered. Cannot be.
No, that was the intention, Your Lordship. There's no mala fide intention.
I am submitting
Okay,
that
my friend is
section 199 of the IPC, which is now 230, would get attracted in this kind of a case. I leave it to the discretion of this Honorable Court. It's a senior officer, coming and making these kind of statements on affidavit. Well, it's in my humble submission, there's no question of taking it leniently because it is a public sector undertaking. You say, you are acting bona fide. If you are acting bona fide, there must be a trace of paper somewhere. It is not one officer sitting and writing a paper. There's an identification committee. There's a review committee. You say you've issued a notice of show cause. Some trace of paper somewhere, some file number. Something has to be there. You can't just simply say that it's not available. And whether officers have retired or not retired, is not relevant. That is why I pointed out, at 3, it goes to the level of the chairman of the bank. And not only the chairman. There are 2 independent directors along with the chairman. It has to be done at the highest level of the bank.
There could have been something with regard to your file number, some details.
I tried my best, Your Lordship.
Which is why, on the last occasion also I submitted
I
this.
kept on asking
It is
them
not
for
only
that. Or
the-
even
It is not only the file is missing.
I don't know.
File is missing. The details. You see,
Something
like
must
the
have
government
happened
office-
somewhere. We do
office
not know
will
what
have
has
some
happened.
File number, something.
Yes.
Nothing
What
is
has happened? Where I said even a piece of paper could have helped us, but something must have happened somewhere. I don't know. We
I
don't know
was-
what is
I
inside,
bowed down.
inside
What is
the
the-
story. But the fact remains that, Your Lordship, the steps, the process had been observed. But how the file went, we don't know. Maybe the petitioner has got a hand there also. Thank you, Your Lordship.
I have a hand.
He cannot.
Thank
He,
you.
If that statement is made, then I'll have to
he
buttress.
cannot do it without your help.
Something has happened somewhere.
But then
That is
if you
what
make
I'm saying.
accusation to him, you see, like
No,
he
I'm
will
not
be-
making it. It's just off the record.
Just
But
a-
something must have happened
Okay, we can
somewhere.
understand.
Nobody is aware.
If that is in jest, that's okay, because otherwise I would have to take very serious
That will
exception
make your
to that
position much worse. If you have to say that he has done it.
If
this is
if there's an
off the record, Your
if there's
Lordship.
an
I'm saying
acquisition
that
against me,
we do
of
not know
having to
what
do
has
something with the
happened,
chairman of
because
the
how
bank,
could the record go missing?
exactly the question,
So
my
we
lords.
do not know what has
Some
happened.
responsibility
We'll go by
fixation has to be
whatever,
there.
whatever
So
is
Your
there,
Lordship may kindly
Some-
pass necessary orders.
Fixation of responsibility will come. Then somebody would have to also fail.
Let us see what we do. Whether we can adopt a lenient approach or not, that also we'll see.
I would only submit, my lords, that it is a public sector undertaking. There is a procedure under the law. You tell the public in general, my lords, the intention of this notice is to tell everybody that he's a willful defaulter. We've identified him under so-and-so, so-and-so. You take the name of the Reserve Bank of India as well. And then you cannot produce the records. You cannot produce a scrap of paper. It is not only a case of misleading this honorable court, my lords, it's a case of misleading the public in general. And that cannot be allowed to percolate whether there is rule of law. There's no question of leniency. As a matter of fact, my lords, this is one of those exceptional cases where somebody has to be hauled up for and some responsibility has to be fixed. It is right up to the level of the chairman.
There is no prayer by you.
My lords, this I could not have anticipated at that stage. This, my lords, has come up in the course of the proceedings. And why I say this is, my lords, that's why I took your lordships to paragraph 12. Because in para 12, this gentleman says that he has access to this particular notice from official records. That means in 2019, the records were available with him. If after that it has gone missing, my lords, somebody in the bank has to answer where has the records gone. Or else, my lords, he was making a false statement on oath before this court saying a notice has been sent. So it has to be either of the two. So either I assume, my lords, on 2019 he was aware of the
repeating the
records.
same thing again and again. Your
Naturally,
Lordship.
my lords, because
It's all right. Your Lordship has heard us and he is going to
I would
pass the
I would therefore pray, my lords, that this is one of those cases that some orders have to flow from this honorable court to fix responsibility. A bank cannot be permitted to act as an ordinary individual.
Let us see.
My lords, highly obliged.
Oblige, Your Lordship.
Item number 6.
Send it to Mike. These books also will be needed, I think. Yes. Petitioner is missing. So So what is to be done? Will
2 weeks, Your Lordship.
petitioner is absent? Just write their name, so and so, so and so.
In this matter, the contention of the petitioner is that the Zimma was granted to somebody who is not the registered owner. So, my lords, for that maybe we'll be requiring the case record.
We'll see. We'll see. Whether in absence of petitioner, will not pass any order.
Right.
See, what you say? Petitioner is absent. So and so, so and so, and so and so are present on behalf of the. You are representing respondent.
Private respondents, Your Lordship, 2 and 3.
And
For the state.
state
I'm representing respondent number 4.
are present. This is matter after 2 weeks.
2 weeks, Your Lordship. Much obliged.
Item number 8.
If it is not there, then we are not passing any fresh
Your
order.
Lordship is there, Your Lordship.
Where is item number 2? The file is there.
Your Lordship, in this case, Your Lordship, in the last occasion, void order dated 11/4 of 2025, Your Lordship, there was an interim stay regarding the petitioner.
Let us see whether it is there or not. Your record will reveal.
In this case, number 25 of 2000.
Let us see. Let us see. Let us see. Let us see. You should make this prayer in presence of the other side. You are not supposed to make it in absence of it.
I beg your apologies, Your Lordship.
You just say in Miss Case 25. You should have told to. This is something
my
very wrong.
apologies,
You
Your
see,
Lordship.
who appeared for the other side? Is he appealable, Mr. Kharkang?
No, I can't.
I think
Can you inform?
Yes, Your
In the Miss Case, you just say list along with criminal petition number 19 of 2025. Stop. The interim order passed earlier shall continue till the next date.
Obliged.
You should see, be able to inform him,
Yes, sir.
inform the council that interim order which was passed earlier has been made, is continued till the
Yes, sir.
interim order.
Apologize, Your Lordship. Much apologize.